In this presentation, we're going to look at exercising regulatory powers and promoting compliance with legislation. The objectives of this presentation is to help you understand the compliance pyramid, what the compliance tools are, why you bother with compliance, the primary roles of the different players, and how compliance relates to those roles, and what shapes the capacity to prosecute. In any government department where you have enabling legislation, you will have regulatory powers that are given to those empowered with the authority to monitor and promote compliance and investigate offences. In performing these tasks, compliance officers are required to have and display a confident and comprehensive and current knowledge of the powers and responsibilities provided by the enabling legislations, so that you know what your limitations and what you're able to do or not do. Enabling legislation is the term used to describe the legislation that gives powers to authorised officers or compliance officers in relation to the regulation of certain activities. It enables certain things to be done. The scope of powers is limited to the activities specifically regulated by the legislation, i.e. the powers to enter, create orders, execute search warrants, or exercise compulsive powers. The enabling legislation may provide for the appointment of authorised officers or invest certain powers in a specific role created under the legislation. It may be by virtue of the position held by the person or by authorisation in writing. More commonly these days, it's by authorisation in writing, and that is a document called an instrument of appointment. The instrument of appointment is crucially vital to establish that you are an authorised officer and you're entitled or you're empowered to act under the legislation. Again, a very important issue is when you go to court, when you're undertaking a prosecution, take your instrument of appointment, because it is how you prove that you're an authorised officer. When someone in the Defence Counsel asks you, are you an authorised officer or an authorised person? They won't just take your word for it. You need to be able to prove that by your instrument of appointment. Where statute creates power or a power, it will generally specify who can exercise that power. There will always be stated or implied responsibilities associated with the exercise of those powers, and they may also place limitations on when and where those powers may be exercised. Compliance and enforcement strategies are somewhat complex, but in a lot of cases, most government organisations look at the easiest and most economical way of doing it. Organisations achieve compliance objectives by employing three flexible and integrated strategies: the enforcement of the law, including the resolution of possible contraventions both administratively and by litigation and prosecution. Administrative sanctions may be such things as suspending a builder's building licence or something similar to that, or imposing a period of disqualification from practising. Encouraging compliance with the law by educating and enforcing customers and businesses about their rights and responsibilities under the legislation. Voluntary compliance, or that education, is very important because it is the cheapest and easiest way to promote compliance. Or the third option is working together to implement these strategies with slightly different approaches, and we'll get into that when we talk about the compliance pyramid. The compliance pyramid is a pyramid where the bottom of the pyramid, which forms the largest part of the pyramid, is self-regulation and cooperation. It then moves up to a mid-tier area of assisted self-regulation. It then goes into active enforcement. And then at the very top of the pyramid, it is prosecution. The prosecution is the most expensive part of the process, so therefore it is generally the last resort. With the education and self-regulation, you may have honeymoon periods where legislation changes and they'll not or the organisation will not prosecute people for a certain period while they educate people on the new legislation. There may be warnings, there may be show cause notices, things like that. There may be audits, monitoring, compulsion. Most commonly, you'll find there will be compliance notices issued with the view of getting the person to meet compliance without taking any further action, or a show cause notice why a person's licence shouldn't be suspended or a period of suspension from practising should occur. After we move up a bit further, you'll get into administrative sanctions such as enforceable undertakings. You'll go into infringement notices. You may have search warrants, and then finally you'll have civil and criminal prosecutions at the top of the pyramid. The guiding principles in promoting compliance is transparency, fairness, and education. Education is by far the most important part of the process because it's the cheapest. Which tool do you use? It depends on the legislation, the impact, context, public perception, public interest, and attitudes. It depends on the nature and severity of the breach. Anything to do with health, safety, or the environment generally has a stronger approach than something that doesn't involve those three issues. It depends on the degree of culpability, the history and related complaints made against the offender or the suspect. Where you have someone who continually disregards the law, you may not enter into any sort of compliance notice, show cause notice. You may go straight to infringement notices, you may go straight to prosecution because previously the lower levels of the compliance pyramid have been ineffective. If there's any cautions that have been issued that have been disregarded, that is generally bypassed after a number of occasions. One of the things that organisations should be able to do, but it is becoming increasingly more difficult because of accountability, is the ability to escalate or de-escalate the matter according to policy and or circumstances. Fairness and the use of discretion is very important, but a lot of those issues relating to fairness and the use of discretion are removed now, and it's more strictly compliant with the legislation. And you've also got to look at the issue of legislation and concurrent use. In all three tiers of government, you may find that legislation deals with the same issue at three different tiers of government. For example, issues relating to the environment. Local councils, state government and Commonwealth governments deal with issues relating to the environment. Generally, you'll try and find what the easiest issue is, who has the most powers, and the simple way to deal with the issue, and that's how you choose which legislation to look at or use. Why do we bother with compliance? It stops unlawful conduct, deters future offending conduct. It undoes the harm caused by the contravening conduct. It encourages the effective use of compliance systems. It may also change the way that policy and procedure is written within the organisation on how to deal with non-compliance. Where warranted, the wrongdoer is punished by the imposition of penalties or fines. You must understand that enforcement is only one component of compliance. Education, advice and persuasion is probably the preferred method by most organisations. Educational campaigns form the base of the compliance pyramid to provide information and advice to customers and businesses. Most organisations take the view that prevention of a breach of legislation is always preferable to taking action after the breach has occurred. Who does what? In the education, planning and conduct of educational strategies, that is the policy area of the organisation. When you're dealing with audits and monitoring, compliance investigations, civil investigations, that's the compliance team. Investigators at the top of that compliance pyramid conduct criminal investigations. The intended action in respect to an allegation must be appropriate in the circumstances and must be able to withstand both external and internal review. The intended action must be able to withstand judicial, in the courts, ministerial, agency or administrative review. Having received the allegation, the first thing to establish is if a breach or offence has occurred. Consider that the complainant does not or will not have any evidence to verify the allegation. What are ways you might corroborate the information provided to you? Is the act or omission a breach of legislation that you are responsible for under your enabling legislation? What do you do then? Having established that the offence has occurred and relevant legislation applies, you need to determine who's responsible for the offence or the commission of the offence, who the alleged offender is. You need to draw a connection or a nexus between the offence and the alleged offender, and you need to understand where the alleged offender is. I know in a lot of local government jurisdictions, a lot of the offences are committed by persons who live in other countries in respect to foreign-owned properties, and the alleged offender may not easily be able to be prosecuted because they're in another jurisdiction, in another country. What shapes the capacity to prosecute? Basically, evidence. Note-taking and recording, records and case management, site visits, collection of evidence, interviewing people, photography and sketches, understanding what is admissible evidence in the jurisdiction that you're working within, and satisfying the necessary legal burden of proof. In summary, it's often difficult to predict how or where the information and evidence gathered by compliance officers will be used in the future. Admissible evidence, correctly obtained, is vital for the success of any compliance action or proceeding. So your notes, records and appropriate case management systems will assist compliance officers and the organisation to withstand both external and internal review.